Happy Friday, everyone. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. Today is Friday, February 13, 2026, 12:30 p.m. New York time, and we are doing our bi-weekly live stream on immigration topics. So as I said, I'm the principal immigration attorney at IS Law Firm. I'm a U.S. Juris Doctor, member of American Immigration Lawyers Association, and I've been practicing immigration law for 20 years, handling all kinds of cases and including citizenship. So today's topic is going to be on naturalization, on applying for citizenship. As regularly we do in this format of today's live stream is going to be with me explaining the qualifications for citizenship, answering hot questions on the current state of the citizenship naturalization process, whether you should wait, you should apply or not. Then I'll go through quickly through basic eligibility questions, requirements for citizenship, the continuous residence, physical presence, and so on, good moral character, then criminal issues, prior immigration history, traveling outside of the United States while your citizenship case is pending, the naturalization process step by step. I'll explain about the changes in the civics test and the history test for naturalization. I'll touch upon de-naturalization topic, which everybody hears about. Anyone who naturalized became a U.S. citizen. Some people are worried that the Trump administration is denaturalizing citizens for various reasons. I'll touch upon this. I'll explain whether it's a myth, whether there's been significant change in that process or not, who actually can get denaturalized, how to protect yourself. I'll dispel some myths, explain whether something is a myth or rumor or it's true, and then we will go into live question and answer session. So what I invite you to do, dear listeners, is to ask any questions you have, whether it's about naturalization process or any immigration process. If you have any questions, you can post it in the chat section, and I will answer all of your questions today live. Again, post your questions early, so I'll go question by question. First come, first serve, and I want to make sure that all of the questions are answered on time during this live stream. I will also answer some of the questions that previously posted on our website, on our social media. So before going forward, I have one favor to ask from you. If you find this live stream or our bi-weekly live streams useful, please press like, please subscribe to our channel. And again, please post your questions. I'll be happy to answer any immigration question you have during any of these live streams. So let's start. The first question is that we're often asked now is, should I apply for naturalization now or wait? So, and this question is always raised in light of Trump administration. They have created obstacles in many immigration steps. There is a lot of enforcement. There is a lot of talk about individuals being arrested or detained at the USCIS offices and so on and so forth. And if someone has some kind of background, they have permanent residency, they may have had some criminal issue or some other issues, and they're worried that if they apply for naturalization now, it will attract attention and it can cause them to even lose permanent residency. So let's talk about that now first. So in terms of whether naturalization applications are going through and people are being naturalized, yes, it happens every day. We are receiving naturalization of ceremonies every week. We received one earlier this week, one or two earlier this week. We receive naturalization interview notices. We have clients attending interviews. Yes, some of the interviews, some of the oath ceremonies sometimes get canceled. It's due to logistical issues. Now, there have been cancellations of the oath ceremonies starting from December for citizens of the 19 countries that were banned under Trump administrations, under Trump's executive order. That includes Iran and Afghanistan. It doesn't mean that those ceremonies are canceled permanently. They are going through some vetting process, they're doing some reviews, but the bottom line is they cannot pause even those ceremonies indefinitely. So you have a mechanism by which you can force the government to schedule your off ceremony, to naturalize you, since you went through the interview. And that mechanism, everybody knows, I hope most of you know this, that's called mandamus action. That's an action filed in federal court, where if you have not had a decision, an off ceremony scheduled within reasonable time, typically that's 120 days or more after the interview, then you can file a mandamus action and force them to schedule your off ceremony, to make a decision on your naturalization application. So they cannot indefinitely hold your case for so-called vetting process. So even that applies even for the citizens of those countries. So you can apply, you can file for mandamus action. In terms of whether you should apply or now or wait, should you apply now under Trump administration or wait until after Trump administration? My answer is apply now. And the reason being is that citizenship gives you additional layer of protection, not additional, but ultimate layer of protection, right? Because the permanent residency is fragile. Permanent residency can be taken away unilaterally by the executive branch, by Trump administration, by the Department of Justice, an immigration judge who reports to the Attorney General, Pam Bondi, and I hope some of you saw her congressional testimony. So to that person, if you haven't watched some YouTube shorts or YouTube videos on who is our current Attorney General, and this Attorney General reports to Trump, and they can make decisions on one way or another. Of course, there is a federal court review afterwards. You can appeal, but it's costly, and it's not everybody understands, and there is certain time period within which you need to file for appeal. You have to have a lawyer to file an appeal. It's an expensive process. The bottom line is losing your permanent residency for various reasons, including this current administration's obstacles they put in the immigration process, or arbitrary enforcement and so on, is very easy. It's very easy to lose your permanent residency. I mean, there are certain crimes for which, if you have been convicted, you may be falsely accused and convicted of something, or if the government alleges that you committed fraud. I mean, we have had clients who came to us once they were placed in removal proceedings after 13 years of being U.S. permanent residents, because the USCIS believed that in securing their permanent residency, they have committed fraud or provided false information, or due to some technical technical mistake by the USCIS, they did not qualify for permanent residency. So at the time when the USCIS reviews their citizenship application, they have decided that, okay, let's look back and place them in removal proceedings. So the permanent residency, long story short, is fragile. You want to apply for citizenship to cover yourself. You've heard about the enforcement under the Trump administration, right? The ICE arrests. Some permanent residents have been arrested, and some of them have been placed in removal proceedings. This was very arbitrary for their opinions, or for speech, free speech, for their opinions that they shared on social media. You don't want to have that. I mean, if you qualify for citizenship at this time or sometime in the nearest future, and you don't apply for citizenship, I think it's foolish. I think it's foolish not to do so. So you should not wait. Now, if you have some questionable background or history on how you obtained your permanent residency, of course, you should consider every detail and communicate with the attorney, consult with the attorney before taking the step of applying for the citizenship, for naturalization. In fact, when you apply for naturalization, it's, especially under the current administration, but in general altogether, it's also foolish not to use professional services to apply for citizenship. Some might say that I'm trying to sell legal services here by doing this. No. Whether you use us or you use someone else who's competent, who's experienced, or more experienced than us, use an immigration attorney. Many applicants underestimate the process of citizenship. They think that it's just filling out the form and submitting. But when you apply for naturalization, it's the last chance for the government to go back in your entire immigration history to review all your prior applications, all of the information you provided in the past, to review and compare it to all of the information you will provide in your naturalization form N400 and the information that you will provide at your interview, at your citizenship interview. So the government reviews the citizenship process as the last opportunity to review your entire immigration history to find out if you lied anywhere, if there was a mistake in granting your permanent residency, if there was inconsistency, and so on and so forth. And it's not necessarily just the Form N400, all those questions there, but it's also what you will be asked at the interview. And in fact, in many cases, the individuals who get in trouble at the time of citizenship, they get into that trouble at the interview where they're asked questions and they give some vague or inconsistent answers. When they're asked questions about past immigration history, about their past background, about their past forms and applications, you can imagine someone who entered the United States on a visitor visa, right? And at one point filed for example, for asylum in the United States. So now you have consular application DS-160 many years ago. You had a consular interview where you gave information and answered questions at the consulate. All of that is recorded and stored in your file. Then you have your asylum application, an extensive form I-589. You provided a written statement declaration. You answered multiple questions, numerous questions during your asylum interview or your asylum hearing in immigration court. Then you filed for green card. You applied, you filed adjustment of status application, I-485. You may have applied for reentry permit or for travel authorization, travel document, employment authorization. So all of this is your immigration history. Your relatives, your family members may have applied. You may have provided an affidavit for someone in support of someone else's case, or you may have sponsored, petitioned someone, sponsored your relative as an asylum. So all of that goes into your immigration file with the USCIS, with the US government. And it's thick usually. By the time you come to the citizenship stage, naturalization stage, they have a trove of information. They have huge amount of information on you. Every question, how you answered, every information you provided is in their file. Now, when you apply for citizenship, what they're doing is they're going through all of this. They're going through all of this, comparing everything to each other. They're comparing what you fill out and provide during your citizenship forms, in your citizenship forms, naturalization forms. They also ask you a bunch of questions at the citizenship. I mean, there have been instances where somebody who applied for asylum and got their permanent residency, they got their asylum, got their permanent residency, and then many years later, they filed for citizenship. And at the citizenship interview, they're asked questions about information in their asylum application, which was probably 6-7 years ago by the time they got the citizenship interview. And at that time, they answered question incorrectly, something sounded vague or inconsistent, and their citizenship was denied, either because the citizenship officer believed that they are misrepresenting information or giving the wrong answer now at the interview, then the naturalization is denied, then you're found lacking good moral character. That means you can only apply for naturalization 5 more years later. Or they had their asylum case almost reopened, and in some cases, their asylum cases have been reopened because of the information they provided, because of the answers they gave at the naturalization interview. And this is not something new. This is not something that has been going on under the Trump administration. This has been going on forever. This has been going on all the time. During the naturalization application, they go back and review your entire immigration history. They ask you questions, and depending on the officer, they ask you trick questions. Some of them ask you questions they shouldn't be asking. So all of that is very confusing, and it's a lot of times there are traps to fall into, hidden traps. So you don't want to just, file the Form N-400 and apply for naturalization. But applying for naturalization and getting you naturalized, becoming a US citizen is very important, because once you become a citizen, your citizenship cannot be taken away as easily as your permanent residency, as your green card. If you qualify, you should apply now. I'm going to repeat that 3 times. If you qualify for naturalization, apply now. If you qualify for naturalization, apply now. If you're eligible to become a citizen, apply now. Get yourself protected, okay? Get a qualified, competent immigration help and get that done. It's very important to protect yourself. Now, basic eligibility requirements, many of you know, the 3-year continuous residency in the US, 5-year continuous residency. Very short, very briefly, if you are permanent resident and have been permanent resident for 3 years, and you have been married and living together with your husband or wife in marital union for the last 3 years, then you're eligible to file for citizenship. So if you've been a permanent resident for 3 years and you've been in marital union with a US citizen for 3 years, you can file for citizenship at that time, meaning you already meet the 3-year continuous resident, 3-year requirement for eligibility of citizenship. Now, there is also, in addition to that, continuous residency and physical presence requirement. Now, if you're not married with a US citizen, if you haven't been married with a US citizen for 3 years, and let's say you got your green card through employment, through diversity visa lottery, through asylum, then you wait 5 years. 5 years from the date on your green card where it says resident since. Now, some asylees will say, no, it's 4 years for asylees, and that's true. By calendar, it's 4 years. And the reason being is because if you have received your green card based on your asylum status, then your green card is backdated. So the date on your green card where it says resident since is 1 year before the date actually you got your green card. So the 1 year before the date you actually got your green card. So again, it's still 5 years. So you look at that date plus 5 years. You can apply 90 days before that 5-year anniversary of your permanent residency. Or in case of 3 years, you can apply 90 days before your 3-year anniversary of your permanent residency. Again, with 3 years, you have to be married to a US citizen. Now, there is a very hot question that many don't know. Even some lawyers give the wrong answer. Is can you apply based on 3-year marriage with a US citizen, even if you didn't get your green card based on that marriage? The answer is yes. The requirement in the statute, in the law, is that you have to be married with a US citizen for 3 years, living in marital union, and you have been a permanent resident for 3 years. That's it. It doesn't say that your green card, your permanent residency must have been based on that marriage. It's not. Okay, so you can apply. Now, the next 2 other requirements, continuous presence, physical presence. Continuous presence means during those 3 years or 5 years, depending on your eligibility, you have not been absent from the United States for a continuous period of time. You've been continuously resident. You haven't been absent from the United States for more than 6 months. Anytime you have left the United States during a single trip and spent more than 6 months outside of the United States during a single trip, you trigger the questioning whether you broke the continuous presence or not. And the answer to this question depends on how long, more than 6 months you spent, and whether you maintained close ties to the United States. So if you spent anywhere between 6 months and 1 year outside of the United States, not more than 12 months, then you can demonstrate that you, despite your absence for more than 6 months, but less than 12 months, you have maintained close ties. You had a bank account, you had driver's license, you had, property in the US, you had relatives in the US, you had some engagements, maybe you had an employment in the US. So it happened that you had to be absent for more than 6 months, but you never abandoned your permanent residency. Now, if your absence is more than 12 months, you automatically break your continuous presence, meaning upon your return to the US from that trip, your 5-year count begins. It restarts. Now, your eligibility time restarts. Now, There are some exceptional circumstances. If you're working for U.S. government, military, you've been, working for U.S. embassy abroad, and so on. There is a way that you can utilize that time you spent abroad as if you never left the United States. The third requirement, so other than the time of your permanent residency status, the continuous presence, the third requirement is physical presence. How much time you physically spent in the United States. So, for example, during the last 3 years or 5 years, you may have not been absent from the US more than 6 months during a single trip, but you may have spent most of the time abroad and you've been coming to the US, visiting, and then returning abroad. That's not a good idea. Watch my previous videos and live streams on this topic, that it doesn't automatically save you from losing your permanent residency. But if you do it, you can prepare. That I think it was last live stream was specifically on that topic. Then in this case, you have to have the physical, at least half of those 3.5 years or 5 years, you have to physically spend in the United States to be eligible for naturalization. So again, to summarize, the length of your permanent residency, the residence since, continuous presence, and the physical presence. Now, the next requirement, so those are the basic eligibility requirements for naturalization. The next requirement is good moral character. And that has, often been overlooked. And it's more important now since October of last year, because they changed the rule, how they're looking into good moral character. It's more important now than it was before. So in the past, the good moral character was, how would I put it? Let's put it this way. You were presumed to have good moral character unless you had something negative in your past. So unless during those 5 years or 3 years, you had been charged with crimes and so on, or you had some issues, you've been accused of fraud, or you lied somewhere in your applications, you provided false information and so on, then you lacked good moral character during those statutory period, or you failed to file taxes or pay taxes, or you failed to pay child support and so on, you wouldn't become eligible for citizenship. But in most of the cases, you could overcome that lack of good moral character by providing evidence that, no, I'm a good person, I rehabilitated, despite all that happened like 4 years ago, 3 years ago, I'm a good person now. Here's affidavits from my employer, from my church, from mosque, synagogue, from community members, from individuals or from my school teacher of my children, saying how good of a parent I am. So you could use that kind of evidence, copies of your tax returns. Maybe you volunteered for some organization, you did something good for the community. You could use that, and you wouldn't have to basically use those things unless you had some kind of issue with good moral character, something that raises a question of good moral character. Now, starting from October of 2025, they changed the rule where you're not presumed to have a good moral character, where the officers, meaning starting from the applications that have been filed or will be filed after October. So if you filed before October, the old rules still apply. So after October 2025, they changed the process where the officers are instructed specifically to ask you for evidence of good moral character, to look closer. So you're not automatically presumed to have a good moral character, but you have to prove it. And the way you would do it, again, I listed those things such as affidavits, information about volunteering, taking care of your children, family, being good family person, and so on, so forth, filing taxes on time. Maybe you employ U.S. workers, maybe they'll provide letters confirming how good of a person you are. And the way you can provide letters, going to the word affidavit, to make it clear, everyone, you can either provide an affidavit to the USCIS or any immigration offices, or even State Department or even immigration court. You can always provide a witness statement in the form of affidavit, which means that you have to, whoever is signing, whoever is providing that affidavit has to do it in front of a notary public, and notary has to stamp and sign that document. That becomes an affidavit. Or the other option is to do a sworn statement, which is easier when you're getting documents, where you're getting such statements from friends, relatives, employer, or your kid's school teacher, from parents in the soccer team that you're coaching and so on. You don't want to overwhelm them and say, hey, write me this, I'm applying for US citizenship. By the way, you need to go to a notary and get it notarized. That's too much, too much burden on them. And not many of them either will be so happy to do it, or maybe it will take time to do it, or some of them may not have time to do it. So you can get a sworn statement. Sworn statement is simple. It's basically, the document is called sworn statement. And the person who writes whatever they want to write about you, about your good moral character. And in the end, there is a special text which says, I confirm, or I swear under the oath, or under the, I don't remember the exact word, under the fear of perjury, that all of the above is true and accurate to the best of my knowledge. And then they have signature and date. The additional requirement for sworn statement is that that person who provided that sworn statement has to attach a copy of their ID, such as state ID, driver's license, passport, or whatever that might be. That replaces the need of going to a notary public. Again, you can do so in immigration courts, you can do so in naturalization applications. So the witnesses can either provide an affidavit, which is a notarized statement, versus sworn statement with that special text at the bottom, and then copy of their ID. Okay, so that will help you to gather that good faith, good moral character evidence. So when you file for citizenship now, you have to file with evidence of good moral character, even if you don't have any significant criminal history, charges, arrests, or even single traffic ticket, right? So you still have to provide. We recommend now filing with the copies of tax returns and so on and so forth. And when we prepare for our clients their naturalization applications, we take care of that. We prepare those statements, we review, we put it together, we gather evidence, we file it on your behalf with all the entire package, communicate with the government on your behalf, and so on and so forth. So contact us if you're eligible for citizenship. Now, prior immigration history, I talked about this briefly, and I'll mention it again. When you apply for naturalization, one of the biggest hidden traps is your prior immigration history. They go under a microscope, review everything you filed. Now, when I say they go, somebody you may know can say, oh, no, I applied for citizenship. I had very quick interview and was approved. Yeah, I had someone I know, seriously, who fell from the 9th-story building to the 3rd story. So it fell about, what is that? That's 6 stories down and survived. Now, is it a good idea to jump or not? No, things happen. Some officers don't do their work or everything they're instructed, or they may have had, quick Friday getaway that they were supposed to go, and they wanted to quickly go over the interviews and approve. So you may be lucky, your interview may go very fast, or the officer who reviewed your entire case, they may not go back to your entire immigration history as thoroughly as they're instructed to do. If you want to take those chances, go ahead, but it's not a good idea. So when you apply for citizenship, you should presume that everything you have filed, you said, you did in the past is going to be reviewed under a microscope, not just because of Trump administration. So the notion that let me not file for citizenship now because of Trump, now they're doing this. No, that's wrong. They've been reviewing this past immigration history, and even more so during Obama administration than, I wouldn't say during Biden administration, but during Obama administration more so, and more so than even on the Trump administration. So you should apply for citizenship, but be very careful whether it's now or you wait and do it later. Better now to get yourself protected. The other part is taxes. So one of the frequent questions I'm asked, whether you should file taxes for those 3 years, 5 years, or for your entire permanent residence in the United States. You need to make sure that you have filed your tax returns for the entire permanent residence in the United States since the time you got green card, or even before. If you were here on work visa, you had some kind of income, you must file taxes. Number one, filing taxes, paying taxes in the United States, that's an independent obligation, and it's more obligation than good moral character for citizenship. That's independent from immigration obligation of anyone who's making income in the United States. For example, if you fail to maintain your status, you're not committing crime. If you work without authorization, you're not committing crime. That's not illegal in criminal sense. That is violation of your status. It's not immoral, it's not illegal, you just become out of status. Or if you fail to do something in your immigration process and so on, you forgot to renew your green card, you didn't file proper documentation, you got denied, that's not illegal. But if you fail to pay taxes, that's a crime of its own. That's illegal, that's criminal. You can be prosecuted for not filing or paying your taxes. And you can have significant financial issues. So whether you're doing for citizenship or not, whether you qualify for citizenship or you have immigration benefit, file and pay your taxes. If you failed to file taxes in the past, don't be alarmed. It can be fixed. You can file taxes to as far back as possible. You can as you want. You can go to a CPA, certified public accountant, to a tax accountant. Make sure you have a qualified one, not some crooks who don't have license to do this, don't have experience. They're just simply, maybe a bookkeeper who wants to file your taxes. Make sure you go to CPA, hire a CPA, and have them file your back taxes. Okay, there's nothing illegal about it. That's formal process. You can go back and fill those gaps. If you fail to file your taxes, let's say during the first year of your permanent residency because you have no income in the US, or maybe you had no income whatsoever, or maybe you were absent from the US, you were on re-entry permit, or you came and got your green card and left the US, you have that gap for 1 year, 2 years, or whatever many years you did not file taxes. Get an accountant, tax accountant, qualified tax accountant, file your taxes. It's never late. Get that done before you file for naturalization. Okay, that fixes those gaps. And now, when you are filling out the form to the question, have you ever failed to file taxes? The answer is no, because you filed it. It doesn't say, whether you failed to file taxes at that time. No, it says, do you have any taxes now? Any overdue taxes? If you have any taxes that you have not paid by the time you have your interview, your naturalization case may be denied, or they may issue request for evidence or continuous notice, and then you have to prove that you did pay. So make sure you get your taxes in order. All of your tax returns filed, at least since you became a permanent resident, and all of your taxes are paid. Now, if you have a large amount of taxes due, you're thinking, how can I pay $30,000 in the taxes now before the interview, before my naturalization application? Then what you can do is you can have an agreement. Again, get a CPA, get an agreement with the IRS, and as long as you have a written confirmation from IRS that you have a payment plan and an account statement showing that you're current in those payments, that will still qualify you for naturalization. So if you have a huge debt to IRS that you cannot pay, or to the state tax authority, so if you cannot pay it before you file for citizenship, get that in order so you have a payment plan, some kind of agreement. It's very easy for CPAs to do. IRS is very willing to negotiate and to agree. They sometimes reduce and let you pay in lump sum, but make sure you get that in order. That's a hidden trap. Many naturalization applications get denied because of that, and then they have to file again and then wait another 10 months, 8 months, in some circumstances more than a year or two, all over again. So get your taxes in order. Child support, I spoke about that. That's a very clear lack of good moral character. Selective service. So selective service, if you have been under 26 years old when you became a permanent resident, you must have registered with a selective service. It's very easy online registration. Now, if you didn't know this rule, now that comes when you become a permanent resident with your green card, they send this instruction. You have to register. It's your obligation to register for selective service. Selective service is basically registering for yourself to be drafted in case of the all-out war, mobilization, and so on and so forth. So you can be selected for military service. If you're male under 26, if you're a male under 26, if you're a man under 26, then you must register for selective service. Now, if you haven't registered for selective service, that's not end of it. You can, as long as you provide an explanation, we usually write a sworn statement, prepare why you didn't register for selective service, what was the issue, why you didn't do it. You weren't just dodging the draft, you just didn't know, and so on and so forth. So with all that kind of evidence, you can still overcome that issue. Travel outside of the United States, we already talked about this. Absences for more than 6 months. Begin prompt questions about your absence. You can explain, provide evidence, and so on of close ties, as long as it lasted less than 12 months. If it's more than 12 months, then your citizenship restarts. The eligibility, the time count restarts when you return. Okay, for naturalization process, just briefly, step by step, you fill out the Form N-400. Again, in the process of filling out, you have to review your entire immigration history, break it down to pieces, make sure that everything is consistent and all that. Again, it's best to hire an expert, an immigration lawyer to do it. I'll say this in every live stream, in every video I make. I say this: nothing in the United States obligates you to hire a lawyer, just like nothing obligates you to hire a doctor or engineer to build a house or a mechanic to fix your car. It's always a good idea not to burn by trying to do it on your own and then getting yourself in such a trouble that will cost you a lot more time, headache, and money to get you out of it. So naturalization is the last realistic step in your immigration journey, in your US immigration process, and don't screw it up by trying to do it yourself after you had a bunch of cases, citizenship, green card, and so on. And everyone has those applications and cases. The USCIS has stack of documents, huge file on you. And if anything in the naturalization, either application or interview mismatches the information you provided in the past, you're in trouble. Either your naturalization is going to be kicked down for 5 years in the future or so, you will have to wait another 5 years, or you may even have your previous cases reopened. Okay, I'm not going to repeat that again, but it's not a good idea to just randomly do it. Now, again, some of you or somebody may say, oh, but somebody did it past. Again, I'll repeat that. I know someone who failed 6 stories and survived. Is it a good idea? No. Okay, so civics and English test. So civics and English test is part of the naturalization process. So you file your N-400, you provide supporting documentation, evidence of good moral character, then you're going to be scheduled for an interview. Now, between the filing and the interview, you'll also have a biometrics notice where you have to go they'll take the photographs, your fingerprints, and so on. If they have any requests for evidence, they may send it before the interview, or a lot of times if they have additional questions, they'll find out at the interview. But they'll schedule an interview for you. They'll schedule a naturalization interview. Some of the naturalization interviews get scheduled and then suddenly canceled. Don't be alarmed. A lot of it logistical reasons. It's not because they're specifically picking on you. It happens a lot. The USCIS is overwhelmed. They are trying to clear all the backlogs. So as strange as it sounds, Trump administration, with all these, enforcement obstacles and issues for immigration, but they're also trying to clear the backlogs so the cases are processed faster. So last time I was at the naturalization interview was about a month ago or so. It was 3 interviews back to back, same day. And I was at the USCIS office in Washington field office in Fairfax, and they had so many applicants at the field office that they had to send others downstairs. So the 2 floors of the building were filled with the applicants with the cases. Some of them the officers don't get to. They're trying to schedule interviews back to back, and sometimes they have conflict because they schedule too many interviews and there is overlap. They have to cancel one, or the officer who was supposed to interview you got sick, or they moved, or they got fired, or they resigned. Things happen. It's life. So your citizenship interview gets canceled. Don't be alarmed. Don't panic. We had a client who had about a month and a half ago interview scheduled, and then it got canceled basically on the day of the interview. And because of this chaos, they often do it on short notice. You may show up at your interview and your interview is canceled. Don't panic. Again, this happens because logistically, they're trying to clear the backlogs. There's a lot of chaos. There is a lot of mismanagement as well, unfortunately. They don't have enough officers, but they have too many cases. They schedule too many cases at the same day, same time. So if that happens, don't be alarmed. So, but at the interview, That's a very important process. Prepare for the interview. If you have a legal representation, that's even better. Many offices still allow your attorneys to appear over the phone, where I, as your lawyer, can appear on the phone and I can participate at your interview and prepare you for the interview beforehand and participate over the phone. That's more affordable than having a lawyer come to your interview and participate in person. But we do it, either way, depending on what you request us to do. So civics and English test. At the citizenship interview, the first questions the officer will begin. They'll ask you to raise your right hand to promise to tell the truth. After you do that, okay, as soon as I raised my hand, my camera started acting up. Let me, okay. All right, I think that's good. Okay, so they will ask you to raise your right hand. This is my kids. I'm working from my home office today, Friday, and this is all my kids' stuff there. So they'll ask you to raise your right hand to promise to tell the truth, nothing but the truth. Then the officer will start with the test questions. In the past, the officer would ask you up to 10 test questions, and you would answer 10 of them. I mean, 6 of them correctly. You could give wrong answers to 4 of the questions, but as long as you answered 6 correctly, then the questioning would be over. So what happened now, since October of 2025, they changed the rule. Now you have to answer 12 questions correctly, and the officer will ask you up to 20 questions. And the number of questions to prepare for it used to be 100, now it's 120. So after you raise your hand and promise to tell the truth, the officer will give you the test questions. Those test questions will be asked from you orally, not in writing, and you will answer those questions orally. One of the answers to the questions the officer will give you, that's going to be 11th question or 7th, the 13th question, or 21st question, that you will answer. Well, the officer will give you the answer and will ask you to write the answer on the iPad. So they have this iPad there, and you'll have to manually write the answer in English language. The requirement is that you answer whatever you write there, your writing has to be understandable. So don't worry about making any spelling errors. As long as someone can read it and understand it, what it means, they're not going to deny your citizenship because you made a spelling error. Now, the rest of the test questions, you should prepare for them very thoroughly, very seriously. I've seen so many intelligent, educated people that took it too lightly, didn't study for the test questions, and ended up having issues where they have to be tested again. Once you apply for citizenship, you have 2 chances per application, meaning if you go to the interview and you failed your interview because you didn't answer the questions correctly, you will have another chance. They'll reschedule your interview, and that will take about 6 months or so. Now, that doesn't mean chances in terms of qualifying for citizenship. If you fail to qualify for citizenship, or if there is lack of good moral character, that doesn't give you another chance. That basically is cause for denial. So they may give you a request for evidence, ask you to provide an explanation, or they can just deny it outright, so your citizenship. And again, in the worst case scenario, they can deny your citizenship and they can reopen your previous immigration application or previous immigration process, and then they can reconsider everything. So be very careful. Now, we spoke about the interview, de-naturalization. So I promised to talk about de-naturalization. That's everybody's concern now, because Trump administration wants everybody to believe that they're denaturalizing citizens and so on. That's not true. The denaturalization has not changed much. It's been in existence. There have been some reports that the number of cases they brought to the federal court have increased, but again, they're hitting the wall because because denaturalization is a very hard process for the government. And it's not something that the executive, meaning the president, can control. It's not something that the attorney general, again, if you haven't watched the congressional testimony of our attorney general, please do. But which was yesterday, I believe, or some shorts from it, watch it. But this attorney general and the president, they cannot control denaturalization. In a sense, they're not the decision maker. For the permanent residency, meaning taking away your green card, the Trump and Pam Bondi are the primary decider, and then you have a right to appeal. Here, if to take away citizenship, it has to be a federal judge who decides. It's almost like charging you with a crime. They have a very high burden of proving that you have committed fraud. Even if the USCIS made a mistake in the process of granting you citizenship, there was something they overlooked. If there was no clear fraud in your process, they're not eligible to denaturalize. But even if there was something like fraud, to prove it, to go through this process, again, it's similar to charging someone with crime. I mean, Trump with the same, allegation, they can say that, oh, we're going to charge with crime everyone, and they did. They said, they're going to try to charge with crime someone who speaks against the U.S. interest and so on and so forth. They're doing a lot in trying to suppress the freedom of speech, but the reality is they're not able to do so. And the reason why they're not able to do so is because the way the United States government is built. We have the executive branch, which is the president, attorney general, immigration courts, immigration judges. I keep repeating that. Many don't understand. Immigration judges are not real judges in the sense that they're not part of the judicial branch. They're part of the executive branch, which reports to the attorney general and then reports to the president, through which they report to the president. So we have the executive branch, we have the a legislative branch, which is the U.S. Congress, Senate, Representative, House of Representatives, and Senate, and we have the judicial branch, which is the U.S. Supreme Court, federal judges, and so on. And then we have states. States have the same. States have their own executive branch, they have their own governor, and then they have their own House of Delegates, Assembly, General Assembly, and then they have their own Supreme Courts, right? So Virginia has Virginia Supreme Court, and so on and so forth. So denaturalization process must be decided. The first person who's going to decide it is going to be the U.S. federal judge, right? So the federal court. And the government, Trump administration, in the denaturalization process is simply the accuser. They're the ones who prosecute this, who they bring the case, and they have to argue, and they have to prove that this person has to be denaturalized. And it doesn't happen quite often, and in many cases denaturalization is denied and the government doesn't succeed. The number of successful denaturalization cases currently, I haven't seen in the last reports that has been more than it used to be historically. So I'm not saying completely ignore the fact that there is denaturalization and the government says that they're going to do more, and they keep saying they're going to do more, but there hasn't been as much yet uptick on this. But it's a lot, it's one of those myths that has not been, just like building the fence at the US-Mexico border, right? So we still have, I don't know how many miles, like maybe 1/100th of the border is built with a fence. And I don't think it will be completely fenced at any time in the U.S. history. So who actually gets denaturalized? So I spoke about this, the fraud, how to protect yourself. Best practice is file for citizenship to protect yourself from deportation, from issues. You never know what they'll come up in terms of enforcement and so on. They will reopen and review green card cases and so on. They can do it. There's nothing stopping the executive from what they're doing now in terms of vetting, reviewing closer, or putting obstacles, putting traps, or reconsidering the permanent residencies, asylum cases, and so on. They can dig, they can re-review, they can reconsider, and they can reopen, even cases in immigration courts. Again, immigration courts report and belong to the executive, meaning to the Trump administration, to the Attorney General, and they belong to the Department of Justice. So they can do all kinds of stuff with you if you're a permanent resident. They can, bully you around. So get your citizenship. That's your right. Apply for citizenship. Get your citizenship. Take yourself away from their influence and become part of the United States citizens, part of the United States completely, in full, not just permanent resident with fragile rights. Okay, so that's pretty much it. I see a lot of questions. Thank you everyone who posted questions. I'll do my best to answer as much as I can. One question I will try to answer from the social media accounts is I don't see it here, but that's fine. So we'll go through the questions. If you have any question, please ask live in the chat section. I'll do my best to answer your question. And if you're watching this video after the live stream, and if you have any questions, post it in the comments. We'll do our best to answer all of the questions, and we will do our best to get to your question, and eventually we will get to your question. And if you liked this live stream, if you find it useful, please like, please subscribe to our channel. All right, so one question is, I understand that you focus primarily on U.S. immigration, but I'm desperate to know about your Iranian asylum in Turkey since UN is no longer active there. How would it apply? No passport. I apologize. I'm just not qualified to give any answer on the asylum in Turkey or any other country. I am a U.S. attorney, U.S. Juris Doctor. I work in the United States, and I'm only qualified to give you advice about immigration into the United States. So unfortunately, Reverie 3, thank you for your question, but I'm not going to be able to answer. So the next part of your question is complicated situation since the I-130 blocked Iranian spouses. No, the I-130 is not blocked for Iranian spouses, meaning I-130 is the first process, first step, the petition. So currently what is blocked is issuance of the visas. So you can file your I-130 for your spouse, and it will go through the process, and it currently takes about 12 to 18 months, and official USCIS announcement that it takes them 49 months. Now, you're going to have a right to file a mandamus action if it takes that long, but you can file I-130, and by the time it gets to the National Visa Center, to the consulate, you'll most likely have this issue resolved, about blocked or paused. One of the federal courts is going to resolve this issue. Folks, if you have any questions, please post it in the chat section. I'll do my best to answer all of your questions today. I mean, now, live. Okay, so the next question is, if someone was previously internationally wanted but won their case in the U.S., received a green card, hasn't left the U.S. or broken any laws, and is now applying for citizenship, how if an Interpol red notice is still active? So, number one, if you had won your case, you can clear your Interpol red notice, right? So the USCIS can discretionarily deny your citizenship because of these things, like, right, for example, if you have, failed to appear in courts, or if you have Interpol red notice and so, but get that resolved. Depends on how well you prepare your citizenship application, your naturalization application, and how well you prepare for the interview. If I was your lawyer, I would first address and target your Interpol red notice. Get that cleared. If you won your case in international court, just like you described, then tackle this Interpol red notice, get it cleared with Interpol, and then prepare very thoroughly and apply for citizenship and prove in your naturalization case that that was a political charge and so on. Your asylum case, maybe if you got asylum in the United States, your asylum case may have been based on this political persecution that you had. And the Interpol red notice, many know this, and many officers don't know this, but some do. Even some immigration judges don't know this, that the Interpol red notice is significantly abused. It's abused by the governments, by many authoritarian regimes. So in your citizenship process, it's almost like preparing for asylum case. You would have to demonstrate the country conditions. You have to demonstrate that the government of your country, whoever issued that Interpol red notice, is abusing Interpol red notices to punish dissent and to punish dissidents and so on. So yeah, it can be done, but you have to very thoroughly prepare. Next question is, does USCIS issue request for evidence in case that needs something after the interview? Yes, the answer is yes. So if the USCIS has questions, if they need some additional document, if it's not a clear ban for citizenship, or you may have filed too early, or you may have filed and you've been absent, you didn't meet your physical presence, so in most cases, those types of cases, they can deny it outright. They can say you don't qualify for citizenship, and that's it. Then you have to reapply. But in the cases where there is a chance that you may explain or provide evidence, for example, if you spend more than 6 months outside of the US, but less than 12 months, now they want to see more evidence that you had close ties to the US during that absence, They can issue requests for evidence, give you a chance to provide answers to those questions, to provide the evidence. And they may even schedule a re-interview, or once you provide that evidence, they may just approve your citizenship by scheduling your oath ceremony. Now, one important thing I want to mention, when you have your citizenship interviews, your naturalization interview, after the naturalization interview, very rarely your case gets approved right away. These officers are overwhelmed. Most of them, they don't even review your case entirely beforehand. They don't do all the background research on you beforehand. They're supposed to. Again, they may do it, and then you have to be prepared for all the questions about your background. But sometimes, and most of the time, they don't have the final decision. They have to look at everything again. So at your interview, the officer usually ends your interview saying that, I'm not done yet, I'll review it and get back to you. Now, they can get back to you either with a request for evidence, they sometimes call it notice of continuance in the citizenship context, or you will receive a notice of your oath ceremony. It takes currently about, I'd say anywhere between 2 weeks to 3 months to get your oath ceremony notice. That's when you become a citizen, at your oath ceremony. So you'll have a notice to appear somewhere where you will take an oath, become a U.S. citizen. So don't be alarmed if after the interview they don't make your decision right away. So for your citizenship. Okay, next question. If someone was previously internationally wanted, okay, that we answered that. How can they find out if there is ever an Interpol red notice for them? He isn't even sure whether a red notice ever existed. Well, get in touch with Interpol. I mean, if there is an Interpol red notice, believe me, the U.S. government will find out. So many people underestimate U.S. government. I see people that file for citizenship, naturalization, and answering to the question, have you ever been arrested or charged? They say no, because they had their records expunged. They naively believe that the U.S. federal government is not going to know that they had some charges or arrests in the past because that they got their some lawyer expunged, meaning sealed the record from the public eyes. You have to understand, you're dealing with the United States federal government, the most powerful entity in the entire world, right? So you have to understand the U.S. government has the most powerful intelligence resources, IT resources. I mean, in some cases, I see applicants for asylum or even citizenship, when they have to demonstrate their residency in the state, they naively show some friend's address in the application because somebody told them that, hey, do this asylum office is better, use this address. And they believe they're going to fool the US government. Yes, again, once in a while, somebody may not do their job. Some asylum officer or immigration judge or the USCIS officer may not do their job properly, and they may overlook. But again, that's similar. Again, I keep bringing this up. I personally know someone who fell from the 9th-story building to the 3rd story of that building and survived. Is it a good idea to fall? No, it's not. So don't rely on these things. The U.S. federal government has the most powerful intelligence, most powerful access. They may see, we know from Edward Snowden files, they could see your camera. They could utilize your camera. The former FBI director, Comey, in answering to that question, said that he seals his camera on his laptop. So something like this. I think he said that. But anyway, bottom line is, and you're asking, how would the U.S. government know that you have Interpol, or you someone you know has Interpol red notice? That's very naive. So they will know. Always presume they know. They know where you are. They know where you had breakfast this morning. They know where you sleep, where you woke up. They know what kind of charges you had. They know every single parking ticket, every single traffic ticket you had, every criminal history, any charge, any incident you had where there was a report filed, even if you're not arrested. Always assume the U.S. government knows this. Not assuming so is foolish and naive. So they know this, okay? So break it down, disclose it, provide, and answering some of those questions can be sometimes tricky. In the forms with us, have you ever been charged or cited for by any law enforcement officer? And you're thinking, okay, a security guard kicked me out of the a bouncer kicked me out of a bar. Is that a law enforcement officer? Are they enforcing? Like, no, they're probably not. But I mean, not most likely, but they're not, unless they were a police officer providing security for something. But you got cited for something. Yeah, traffic ticket is a citation. So disclose that. Don't hide the information, right? That's the one important thing to remember for any immigration process. Don't hide the information. If you're answering no in the form, but if you have questions in your mind, maybe I should have disclosed in the addendum in the application, disclose the information. That will save you from finding of material misrepresentation, where you can become inadmissible, meaning you will never become a permanent resident of the United States unless you have qualified U.S. citizen or permanent resident relative. You qualify for a waiver, which is not everybody will qualify. It's expensive, lengthy, and questionable process for many. Or your citizenship is going to be denied, and so on. So make sure you disclose anything that you're thinking, should I disclose? You got your record sealed, expunged, still disclose that information. Okay. For those who applied before October 20, are they having old civic test or new civic test in the process regardless of application? Very good question. Yes, old civic test. So if you applied before October 20, 2025, which is the time when they changed the civic test and they changed the meaning number of questions asked and the type of questions asked and the affirmatively proving your good moral character. If it was before October 2025, October 20, 2025, you filed, the old rules apply to you. Okay? The filing date controls, even if your interview is scheduled now. But if you filed on October 2025 or after that, then you better be prepared for the new test. Now, even if you filed before October 20, 2025, in terms of evidence of good moral character, we do recommend strongly gather your tax returns and so on when your interview is scheduled. Be prepared for thorough examination and detailed examination. Not, again, the civics test, I already answered. You don't have to prepare the 120 questions and so on. The old test applies. But everything else, because a lot of it is discretionary, be very prepared and still bring your tax returns, evidence of good moral character as much as you can. Because you have to understand those officers. Those officers, they look at that date for civic tests, but everything else, they also have difficulty toggling between these dates. Okay, should I ask this person about their good moral character more than someone whom I had interviewed right before this because they applied on October 21st, 2025. This one applied on 19th October. So it becomes, so just make it easy. Your goal in any immigration application, I always tell my clients, look, you can always prove your point. You can fight. You can say, I'm protecting my rights. Our goal here is to get your green card, your visa, or your citizenship as smoothly as possible. You can prick the officer with your rights and say, no, I applied this. That's why I'm not going to show you good moral character. But you want to do it. I mean, your goal is just get your naturalization, get your protection, and move on. All right. So hopefully I answered your question about this. So next question. Most immigration attorneys does not advise like you. Who's that? Coruscant 5 DCT. Please let me know, what do you mean by in what way do I differ? Even if they regularly got successful in citizenship matter. I'm not sure I understand. They don't tell anyone to apply directly for citizenship. Are you really asking me to apply? Are you lawyer attorney? Yes, I am. I do recommend you to apply. If you qualify for citizenship, for naturalization, apply. Again, first consult with an immigration lawyer to review entire immigration history. Always recommended to hire an immigration lawyer for the process. Go back, if you haven't reviewed the beginning of this live stream, go back and view why you should apply. But I'll repeat quickly here. Citizenship protects you. Under the current administration, the current immigration environment, it's more important than even before to be protected. They cannot take away your citizenship easily. De-naturalization is a very hard process, but they can take away your permanent residency. If you qualify for naturalization, file it. We get individuals naturalized. We get our clients naturalized. The oath ceremonies get scheduled. very frequently. We just got one yesterday or the day before yesterday of ceremony scheduled. We're frequently attending citizenship interviews and getting clients naturalized. The naturalizations take place, the interviews take place, and they get approved. You have to be very thoroughly prepared. Now, in terms of looking back in your immigration history, that hasn't changed much. It's been the same under Biden, it's been the same under Obama administration, Bush administration, and it will be the same after Trump. So don't fall into that trap of, oh no, don't apply now, they'll look closer. They'll look closer still. Now there are some cases, again, the officers don't look as close as they're supposed to. And let me give you a little actually insider information. I told you previously about the current state of all those officers who are scheduled to interview 20 applicants on the same day, and that's why some interviews get canceled. But there is one logical thing that you can conclude from it, that those officers often, and I see it more so than before, they don't often look as close to the file as before under the Trump administration, because they are overwhelmed, because they have too many applications filed. So you may get naturalized faster and easier now than you would under prior administrations. The bottom line is, despite all this, how close do they look or not? Still, how closely they scrutinize you, how much they pick on you. Apply for citizenship as soon as possible. Now, as to your question whether I am a lawyer attorney, since you're on our live channel, please go and review the information about me. I am a licensed immigration lawyer. I've been practicing U.S. immigration for 20 years. I am a U.S. Juris Doctor, and I'm a member of American Immigration Lawyers Association. I've been handling citizenship cases, asylum cases, all kinds of immigrant investor visa cases, work visas, and so on for the past 20 years. Again, I'm a licensed immigration attorney. Now, why am I keep repeating that, not advertising myself? I want to make sure you understand that when you deal with these questions, when you are asking for advice as to whether you file for citizenship, should you, or hire individuals, make sure they are licensed immigration attorney. Make sure they have experience in this field. Make sure that they're licensed U.S. immigration attorney. Now, I'm often asked, what's the difference between lawyer and attorney? Lawyer is someone who has a legal education, right? So although in language we use it interchangeably, we say lawyer and attorney. You see, like my signature says, Ismail Shahtakhtinski, ESQ, attorney and counselor at law. So attorney is licensed lawyer who is licensed to represent it. It's just like doctor, right? So you can have a medical graduate, right? So they're not MD, they're not medical doctor. That MD after the name makes them eligible. That means they're licensed to provide services, to provide medical services. Similarly, attorney is the one who can provide legal services. Just because somebody has legal education from somewhere in the world, or even in the United States, if they're not licensed, if they don't have experience, it's not a check mark. Don't hire individuals who call themselves lawyers or law firm, or they help you with the forms. Believe me, there is not a single week, I wouldn't say a day, I don't want to exaggerate, there is probably not a single week that I don't face it with a consultation where somebody tells me, somebody filled out the forms, forms provider LLC, or this, forms this, some individual who's not a licensed licensed lawyer, licensed immigration lawyer, they fill that and they end up in trouble. They end up, because you're saying many don't tell anyone to apply directly to citizenship and so on. So again, make sure you deal with only lawyers and with attorneys, not just lawyers, but attorneys. So attorney is a licensed lawyer. Lawyer, anyone who has legal education. Somebody from abroad who had a legal education come here, they're still a lawyer. They deal with laws, but they're not able to represent clients in immigration applications, in the immigration courts or other courts. Okay. All right, next, are you a lawyer attorney? It's the next question. Under what circumstances does USCIS cancel an off ceremony, and what steps should applicant take afterwards? So off ceremony can be canceled similarly to the interviews. Don't be alarmed, don't panic. They can be canceled simply because they overbooked, simply because something happened logistically. So there's a lot of mismanagement. There are too many applications, too many off ceremonies being scheduled, and that's why there is some logistical issues for which a lot of ceremonies may get canceled. They don't get canceled as often as it gets reported, but some do get canceled, including interviews. Don't panic, don't be alarmed. Now, if it gets canceled, then you don't get it rescheduled within 120 days. Make sure you make inquiries, and then you always have the right to file a lawsuit in federal court called mandamus action to force the government to reschedule and to naturalize you. So now for the 19 countries, right, citizens of Iran, Afghanistan, I think it was Zimbabwe, some other countries, there is a list. I don't remember all from the top of my head, but for those individuals, they canceled off ceremonies, again, saying that they need to vet and look closer into their past immigration history, but they cannot keep doing that. They cannot keep it for more than 120 days. They basically over the board announce they'll cancel all ceremonies until the vetting is done. But again, they have by law, by regulation, they have 120 days. If they still keep without scheduling within reasonable, typically we recommend about 6 months from that. Although the regulation says 120 days. So if 6 months, it's not reasonable, then file a lawsuit in federal court. Get mandamus action, get that done. Okay, next question. Are you live in New York? No, we have a New York office. And now 99% of the immigration services are done remotely and online. We have very technologically advanced system. You can upload the documents. You never have to come to our office. We have offices in Virginia. We have office in New York. But we practice all over the United States, in fact, all over the world in relation to the U.S. immigration. So you can contact us. We'll take care of you, whether you are in New York, in Virginia or not. But we have one office in New York, and I frequently visit that office. So in terms of where I live, I'm not going to disclose it. I live everywhere. I'm the citizen of the world. But where we practice in New York, in Virginia, California, Texas, Louisiana, all over the place. All right, so next, if the visa officers ask me, are you going to stay in USA, what will answer him? Well, depends on the officer, what visa, and what is that you're doing. Where are you going to stay in the US? What will I answer him? Depends on, there is just too many factors. How to detect authentic attorney, review the background, review the history, review the information, go online. If they claim to be an attorney in a state, for example, I'm licensed in Virginia, Maryland, Washington, D.C., and New York. So I'm licensed in all those jurisdictions. You can go to their state bar associations and review. Bar means any attorney, because the place where the attorneys practice, where the judge sits, that looks like a bar. So that's why it's called bar. So state bar associations, they have information about each attorney. So you can look up online their license information and so on. I mean, successful experience. Again, look at the reviews, look at the information online. Thank you, friend. Thank you for all your questions. If the visa officer asks me why I grant you visa, what should I answer him? Again, so ma'am, it depends on the type of visa you're applying. It's very specific. Schedule a consultation with us. We'll be happy to answer, and we'll be happy to help you with your visa application. Thank you, everyone who joined. For everyone who viewed and who will view this, who will listen to this after the live stream, please press like. Please don't forget to subscribe and join us 2 weeks from now on our next hot topic on U.S. immigration laws. Thank you very much. Have a nice weekend. Bye-bye.